Brunswick today, and I do have a couple of major topics to address with the board tonight, so I appreciate the opportunity to speak to you. I have to start with a question for... Yes, that's right.
He's previously sworn.
Okay. So I want to understand, Mr. Chairman, do you believe in climate change? Specifically, do you believe that humans have been and are continuing to cause increasingly extreme weather and things like sea level rise?
Mr. Chairman, if I may, we can't speak for the board.
Correct.
I asked Mr. Chairman.
And I'm not going to discuss that.
You're not going to defend. You're not going to take a side on climate change.
No.
Okay. Well, then I don't think that you should continue to be the zoning board chair if you're not willing to come out in at least admit that we have a problem with climate change. And so I'll get to why I'm talking about that.
Mr. Kratovil, if I may, the chairman and members of the board are limited to opine on what the municipal land use law permits them to opine about. I don't know that there's anything there that requires them to take a position on climate change, and quite frankly, I don't think that it's a very simple topic where a person can say they have just one position that they believe all things. But certainly you can ask the questions. I think that just so that we know the parameters, however, the chair and the board members are limited to opine about those things that are permissible under the municipal land use law. That's their authority here. Just by way of example, I mean, he may believe very strongly in going to church every Sunday, but certainly that doesn't have a place in whether the municipal land use law permits him to opine about that or make that a condition of approvals.
Sure. So let me explain where I'm coming from then just very briefly. Obviously, my concern is about the environment, the planet, clean water, clean air, and of course, land use has impacts on our environment, and that's why I'm asking, because I think that we should have a zoning board that has everyone on it who believes that climate change is a human-caused problem that needs a human solution, and that government entities should be using their power to help guide us towards that solution, and that includes land use decisions that are made. And so, there used to be a time when you'd have to worry about if you rent an apartment in Brunswick, you'd have to worry about the wrecking ball coming and your house being condemned, taken by eminent domain, demolished by a demolition company. But these days, you also have to worry about some of these reckless real estate companies with their greed and corruption, leading them to cut corners, shortchanging worker safety and the planet, and indeed the safety of our community at large. And we saw this manifest itself just last night when a construction crane was taken down by a storm, extreme weather, right? Extreme weather is becoming more and more common, and that situation alone endangered many lives. Thankfully, this time no one died, no one was hurt. That was a miracle, obviously. The neighborhood's a little quieter this time of year, and thankfully nobody got killed. But it is now incumbent upon all of us in this community, not just this board, not just the residents, but the planning department, the rest of the city administration, to immediately work to raise our standards so this never happens again. The reason I'm here is this board did approve that project unanimously in June 2017 over the objections of some community residents and based on representations of an attorney who, in my view, shouldn't be representing applicants at this level. But before I continue, I do want to ask, what conditions does the board typically put on applicants regarding safety of the construction site, the operations of the site? Is that something that the board's ever put a condition up on?
Mr. Chairman, specifically with, and if I may, if it's related to the accident itself, that's a construction issue, so the board certainly would ask that they follow not only the Uniform Construction Code, which is inherent in every approval of the grant prior to the issuance of any building permits. But there are also OSHA standards, which is a federal statute, or federal statute. They still need to follow the law.
Of course. I'm just trying to figure out if there's anything more this board can do when applicants that are going to be requesting a build, say 100 feet or taller, are going to need to be bringing in large cranes. Is there anything we can do to make sure that there's more safety or hold them more accountable for the choices they make as to which companies they hire and what those companies' track records and reputations are? And so I would encourage all of us to research this and see what we can each do in our own capacity to hold these folks accountable. You can believe I'm certainly going to do that with the folks that were involved in this particular, disaster. And, I'll just say, as we move forward, the board should take into account, past actions and statements of the applicant, as well as their experts and their attorneys who've come before the board before. And of course, this was an attorney who's the most common attorney to represent clients here. And so I'll refresh your memory for those of you who might not have been here earlier this month. On July 8th, this board held a hearing for applicant Recon Services, also represented by Mr. Thomas Kelso, who also represents the county government. That hearing had been postponed twice before, once because the applicant and their attorney failed to give proper notice to the neighbors. The second time, your agenda was full and they weren't able to fit into the agenda. So you went out of your way to schedule a special meeting just for this application. And in the testimony taken at that hearing, you'll make clear a few facts. First of all, that the applicant initially requested a waiver of the requirement to create an environmental impact statement regarding the impact their project would have on the environment. And secondly, at some point in January or February, the applicant claims they changed their mind and then submitted an environmental impact statement. I did, I take pride as a journalist in making proper legal requests for government records to assist me in my news gathering efforts, and I often share the records that I obtain with other community members, and this particular application was no exception. As I indicated in my testimony on July 8th, I had requested the application at all exhibits and attachments through an OPRA request, Open Public Records Act request. That's for all to see on opramachine.com. And that request was made in April, and no doubt the city's planning department was involved in producing the response that was ultimately shared with me via a Google Drive folder. And I then, as a journalist, shared that with community members, including individuals who I knew were concerned about that project, and just the community at large. We have a large audience on our Facebook page, and that link was shared widely multiple times with the community. However, the link takes you to a response that omits the EIS. The environmental impact statement was not provided to me by the city, and in fact, no withdrawal of the waiver is in there. So anybody who looks at those documents is going to get the impression that there's a request for a waiver of an EIS, not an EIS. And of course, my right to review that, the complete application, including EIS, was violated by that insufficient response to my lawful OPRA request. And this was a concern I raised. I did ask the board respectfully to hold off and adjourn. I could have rescheduled for tonight and given me and other community members a chance to review that environmental impact statement before taking the vote, but this board chose not to do that and indeed unanimously approved the project. I followed up, was not able to get an EIS after you adjourned that night. No one had one that they could share with me, and unfortunately, it took another week or so before I could actually get it. I did get it, and I have an excerpt from it here, but first I want to ask, were each of the board members provided with a copy of the EIS at the time of your vote?
Mr. Chairman, if I may, and I think Mr. Kratovil and I may have discussed this, and I apologize if it was maybe something that I thought that we discussed. It happens in old area sometimes. I have conversations that didn't actually happen. So I think that what we may have discussed was that in the normal course of events, the application itself and all supporting materials are provided, under the municipal land use law, are to be available for public inspection during regular business hours. We try to make it available on the website as well. I think we were having some issues with getting things onto the public drive so that it would be available for public display. Under municipal land use law, the application and any supporting material have to be available for public inspection, including any amendments or changes that may have been made, at least 10 days prior to the hearing itself. And I don't want to speak out of turn because I can't, I see enough applications where I made a mistake one for another, but my recollection was that the environmental impact statement for this application was submitted at least 10 days prior. Those applications are available for the board members and all supporting documents as well as part of their application review process. They do have an opportunity to review all of those documents, which I'm sure that they do. I can't speak for everyone, but certainly they are available for them to review, and they listen to the testimony that's provided. If additional information is necessary, then the board members will certainly ask to either additional questions, follow-up questions, or ask for additional time so that they can digest that material. But in this case, I believe the EIS was in fact part of the application at least 10 days prior, but may not have been part of your OPRA request. Could be dead wrong on that, Mr. Kratovil, but I'm sort of thinking that that's why it wasn't provided. I don't think it was because there was a purposeful or deliberate act to not provide that to you.
And I wouldn't suggest the same.
No, I don't think that you would have.
Right. But yeah, no, my question, however, was with regard to whether the board members were provided it. So yes, it was available if they had requested it, but for instance, were they given the same Google Drive link that I was, and it really wasn't provided to them? How did I'm asking the board, did you guys see the EIS? Did you read it? Did you review it before your vote?
If they recall it.
All of the paper documents that were submitted in the file, I do put on the table for the board to look at architecturals and plans, and if there's other sort of addendum documents, engineering reports and environmental reports and so on and so forth. So I did put all of those documents on the, they were on the table.
And we got it electronically also. I think it was emailed to us. I'm pretty sure.
Okay. Well, I do have that excerpt for you, and I'd like, if you would be so kind to just take one and pass it down. This is just one page of it was a 6-page document with a cover page and an appendix. This is page 4 of 6. And I have a question. It came up, there was a woman here who asked about the sort of historic assets that might be disturbed by this development. And it was alluded to that, okay, that's inside the EIS. And so I'll draw your attention to this is section 4, environmental impacts, subsection C, scenic and historic qualities. And it's only 2 sentences, so I might as well read it into the record, and you can tell me how to get to this place. There are no distinct scenic or historic qualities located on site. The Buckaloo Mansion Museum and the Kirk Pub are located within the vicinity of the project, but will remain undisturbed during and after the construction of the project. How do I get to the Kirk Pub? I've lived in New Brunswick a long time, never heard of this place. Okay, so I'm certain that you guys, many of you lifelong residents, you know the city very well. You would know if there was a historic thing called the Kirk Pub in New Brunswick, and I think that the fact that none of us can identify the location, I've never heard of it, tells us that that's an error in this EIS. And so that's the only section that I've really fact checked.
It could be.
Maybe
it's Kirkpatrick Chapel.
I'll think an acronym or something.
Yeah, that's what I think.
You have to ask the author.
Yeah, I mean,
Yeah, and this would have been exactly what I would have done during the hearing if I had had the opportunity to review the EIS before the hearing. I would have asked the applicant, I would have said, what the heck is this?
Mr. Chairman, I think that it certainly would have been more relevant if the EIS had said that it would have impacted it.
right, that's what I was just gonna say. So because it said that if nothing was gonna be impacted, it didn't really raise my attention.
Fair enough, but I would suggest that, if it is an allusion to the Kirkpatrick Chapel, which is a historic location, that's 10 blocks away from the site in question. Buckaloo Mansion is also not terribly close. There's other historic buildings closer, so I would suggest that this is an incomplete assessment. This is an incomplete review, and the fact that only 2 sentences are applied to the historic nature of the 6th Ward of New Brunswick. If you're going to include Buckaloo Mansion and Kirkpatrick Chapel, many blocks away, there's a lot more to include, actually. This deserves more than 2 sentences. This is a sloppy EIS.
But Charlie, if I may,
Yeah, of course.
so our job, as I know it, is to look at variances that are given to us. And so when I look at this, I look to see what impact it has on the variance. This has no impact. So therefore, I don't, and please correct me if I'm wrong, I don't think that we're the board that has to do with historic properties, and I agree with you, we should preserve historic properties in New Brunswick because there are some that are very, very important.
Absolutely.
But I'm not sure that we're the board that has to do with that, and I could be wrong.
That's correct.
Okay.
No, and I'll admit, I've got a lot to learn too about how municipal government works, and how, you know, different boards have different powers, but from my perspective as a concerned resident, reporter, I'm just fact checking what the developer's claiming on the record here, and so I'm concerned that they didn't really give the environment or the historic nature of this neighborhood the due diligence that it needs, and really they didn't do their job. If they're going to do an EIS, they should have done better, and that this project shouldn't have been approved with a sloppy EIS, in my opinion, right? Because I think that if they want all these variances to build a huge building, they should hold themselves to the highest standard, and it shouldn't have been a second thought to adjourn the hearing because the EIS hadn't been given to the public. It should have been real simple. Okay, this is a big project. We want to get it right. Make sure the public has their say. That was a mistake, in my view, not to give the public the time to review this. And now, unfortunately, it's too late, and I do have to raise one more issue before I'll give the floor.
I'm sorry, Mr. Chairman, if I may. Mr. Kratovil, I'm not sure I understand what you mean by it's too late. I think that we had discussed this before. There is a 45-day appeal period. So it's not too late.
So you're suggesting I could file
I think the
civil litigation?
board has taken the action that it must take within a certain period of time. There's the public or anyone that has any objection to the approval or the actions of the board can pursue a prerogative writ action. And that's not been, I mean, your right to pursue that has not been prejudiced. And I know that you're not trying to imply that, I just want to make the record clear, and the board members certainly understand that, you know, they're not the final say. There's always an appeal.
That's a good point, and you know, for the record, I am considering that, and I'll give you the other reason I'm considering that is that, you know, there was a statement made on the record in response to Ms. Cicconi's questions that night. She had asked whether the environmental board was going to have some, whether they had the opportunity to review the elusive EIS. And
Mr. Chairman, if I may,
yes.
and I apologize for interrupting you, but actually it's something you did say. You just said that you're considering a prerogative writ action, and advised the board that this application can no longer be, at least as long as there's a pending or potential for a prerogative action, as Mr. Kratovil has indicated, that we not discuss this application or entertain any additional questions about it. You can certainly make any comments.
Thank you. Yeah, I don't have any more questions. I guess, you know, just a comment, and that would be that you know, Mr. Dominguez at the last meeting had made statements that strongly implied that the Environmental Commission had the opportunity to review the EIS and the full application, and that was par for the course. And the following night, I went to the Environmental Commission, and they had trouble getting a quorum, and there were only 2 people who showed up, but both of them said we had not seen that, we did not get that. And I've since brought it up to the City Council, since had discussions with Mr. Dominguez, and have been assured that the changes are going to be made to the process to assure that the Environmental Commission does have the opportunity to review these important applications before they get to the TAC, before they get to these hearings, and ultimately, I think that's a good move. That's a best practice that should be in place, and I just wanted to correct the record and state that that's another reason I'm concerned. Again, it's concern coming out of the you know, desire to live in a clean, healthy place with clean air, clean water. This was a site that had groundwater contamination, had 700 plus cubic yards of contaminated soil. The developer tried to originally get out of doing the EIS, then did the EIS, but it wasn't shared with the public, and then combined that with the, you know, the inaccurate depiction of what had gone on with the Environmental Commission collaboration. And now I am in a position where I am considering challenging the what I would characterize as a rushed approval of that development. And I would just encourage the board and your attorney, if there's anything that we can do to avoid that, let's work it out. I'm willing to talk to anybody. You know me. I'm not hard to find, and I'm not shy. So I'll talk to whoever about what we can do to make sure this stuff doesn't happen again. And I hope you know, take some of my comments to heart. I do appreciate the opportunity to address you tonight. Thank you.
Thank you.
Thank you.
Any discussion items that we need to discuss?
So our next meeting will be at 7?
Yeah, so what had happened was that everyone, the attorneys had noticed for 7:30. I found out right immediately afterwards, and so as to not ruin this meeting, I opted to not notice, but I'm submitting several notices this week, so it'll be taken care of.
I would have
Yeah,
been really late.
We will be at 7.
So going forward,
Yes,
the meetings
and
will all start at 7.
all the meetings. So not just for the summer hours, but for the rest of the year, and we'll see how you guys like it. You may continue it next year as the board likes to continue.
Do I have a motion to adjourn?
So moved.
Second. All in favor?
Aye.